Non-disclosure agreement. This non-disclosure agreement is made as of the day by and between TSS Marketing, the company, and person/company counterparty. Each party has disclosed and or may further disclose its confidential information as defined below to the other in connection with the relationship as defined below, pursuant to the terms and conditions of this agreement. As used herein, the term disclosure shall refer to the company whenever the context refers to the company's confidential information being disclosed to counterparty, which is referred to as recipient in that context. Recitals. The parties wish to explore a possible business opportunity of mutual interest regarding becoming one of our 4,500 partners, earning weekly payouts. We are building the backbone infrastructure of DECA Data Center, the relationship, in connection with which disclosure has disclosed and or may further disclose its confidential information as defined below to recipients. This agreement is intended to allow the parties to continue to discuss and evaluate the relationship while protecting disclosures' confidential information, including confidential information previously disclosed to recipients, against unauthorized use or disclosure. In consideration of the premises and mutual confidence herein, the parties hereby agree as follows. Number 1, definition of confidential information. Confidential information means information and physical material not generally known or available outside disclosure, and information and physical material entrusted to disclosure in confidence by third parties. Confidential information includes, without limitation, brand names, product ideas, intellectual property applications, technical data, trade secrets, know-how, research, product or service ideas or plans, software codes and designs, algorithms, developments, inventions, patent applications, laboratory notebooks, processes, formulas, techniques, mask works, engineering designs and drawings, hardware configuration information, regulatory information, medical reports, clinical data and analysis, reagents, cell lines, biological materials, chemical formulas, agreements with third parties, list of or information relating to employees and consultants of the disclosure, including but not limited to the names, contact information, jobs, compensation, and expertise of such employees and consultants, list of or information relating to potential and current suppliers and customers, price lists, pricing methodologies, cost data, market share data, marketing plans, licenses, contract information, business plans, financial forecasts, historical financial data, budgets or other business information, or information which would, under the circumstances, appear to a reasonable person to be confidential or proprietary, that is disclosed by disclosure, whether by oral, written, electronic, graphic, or machine readable format. Number 2, non-disclosure of confidential information. Recipients shall not use any confidential information disclosed to it by disclosure for any purpose other than to carry out discussions concerning and the undertaking of the relationship. Recipients shall not disclose or permit disclosure of any confidential information of disclosure to third parties or to employees of recipients other than directors, officers, employees, consultants, and agents of recipients who are required to have the information in order to carry out the discussions regarding the relationship. Recipients shall take reasonable measures to protect the secrecy of and avoid disclosure or use of confidential information of disclosure in order to prevent it from falling into the public domain or the possession of persons other than those persons authorized under this agreement to have any such information. Such measures shall include the degree of care that recipient utilizes to protect its own confidential information of a similar nature. Recipient shall notify disclosure of any misuse, misappropriation, or unauthorized disclosure of confidential information of disclosure, which may come to recipient's attention. Number 3, exceptions. Notwithstanding the above, recipients shall not have liability to disclose with regard to any confidential information that A. was in the public domain at the time it was disclosed, or has entered the public domain through no fault of recipient. B. was known to recipient without restriction at the time of disclosure, as demonstrated by files in existence at the time of disclosure. C. was independently developed by recipient without any use of the confidential information, as demonstrated by files created at the time of such independent development. D. is disclosed generally to third parties by disclosure without restrictions similar to those contained in this agreement. E. becomes known to recipient without restriction from a source other than disclosure without breach of this agreement by recipient and otherwise not in violation of disclosure's rights. F. is disclosed with the prior written approval of disclosure, or G. is disclosed pursuant to the order or requirement of a court, administrative agency, or other governmental body, provided, however, that recipient shall provide prompt notice of such court order or requirement to disclosure to enable disclosure to seek a protective order or otherwise prevent or restrict such disclosure. 4. Return of materials. Recipient shall, except as otherwise expressly authorized by disclosure, not make any copies or duplicates of any confidential information. Any materials or documents that have been furnished by disclosure to recipient in connection with the relationship shall be promptly returned by recipient, accompanied by all copies of such documentation within 10 days after A. the relationship has been rejected or concluded, or B. the written request of disclosure. Number 5, no rights granted. Nothing in this agreement shall be construed as granting any rights under any patent, copyright, or other intellectual property right of disclosure. Nor shall this agreement grant recipients any rights in or to disclosure's confidential information other than the limited right to review such confidential information solely for the purpose of determining whether or not into the relationship. Nothing in this agreement requires the disclosure of any confidential information which shall be disclosed, if at all, solely at disclosure's option. Nothing in this agreement requires the discloser to proceed with the relationship or any transaction in connection with which the confidential information may be disclosed. Number 6, no representations made. Recipient acknowledges that neither discloser nor any of its representatives, in the course of providing the confidential information or as contemplated hereunder, is making any representation or warranty, express or implied, as to the accuracy or completeness of any such information, and recipient assumes full responsibility for all conclusions derived from such information. Recipient shall be entitled to and shall rely solely on representations and warranties made in a definitive agreement, if any, relating to the relationship. Number 7, no reverse engineering. Recipient shall not modify, reverse engineer, decompile, create, or other works from or disassemble any software programs contained in the confidential information of disclosure unless permitted in writing by disclosure. 8. No publicity. Neither party shall, without the prior consent of the other party, disclose to any other person the fact that confidential information of disclosure has been and or may be disclosed under this agreement. That discussions or negotiations are taking place between the parties, or any of the terms, conditions, status, or other facts with respect thereto, except as required by law, and then only with prior notice as soon as possible to the other party. 9. Notice of compelled disclosure. In the event that recipients or any person to whom they or their representatives transmit or have transmitted confidential information become legally compelled by oral questions, interrogatories, requests for information or documents, subpoenas, civil investigative demands, or otherwise, to disclose any such confidential information, the recipient shall provide the discloser with prompt written notice so that the discloser may seek a protective order or other appropriate remedy, or both, or waive compliance with the provisions of this agreement. In the event that the discloser is unable to obtain a protective order or other appropriate remedy, or if it so directs the recipient shall furnish only that portion of the confidential information that the recipient is advised by written opinion of its counsel is legally required to be furnished by it, and shall exercise its reasonable best efforts to obtain reliable assurance that confidential treatment shall be accorded such confidential information. Number 10, common interest agreement. To the extent that any confidential information provided or made available hereunder may include material subject to the attorney-client privilege, work products, doctrine, or any other applicable privilege concerning pending or threatened legal proceedings or governmental investigations, recipient and discloser understand and agree that they have a commonality of interest with respect to such matters, and it is their desire, intention, and mutual understanding that the sharing of such material is not intended to, and shall not, waive or diminish in any way the confidentiality of such material or its continued protection under the attorney-client privilege, work product doctrine, or other applicable privilege. All confidential information provided or made available by disclosure that is entitled to protection under the attorney-client privilege, work product doctrine, or other applicable privilege shall remain entitled to such protection under these privileges. This agreement and under the Joint Defense Doctrine, nothing in this agreement obligates disclosure to reveal material subject to the attorney-client privilege, work product doctrine, or any other applicable privilege. Number 11, terms. The foregoing commitments of such party shall survive any termination of the relationship between the parties. All confidential information shall be safeguarded by recipient as required by this agreement for a period of 3 years from the date of this agreement, with the exception of trade secrets, which must be safeguarded by recipient in any perpetuity or for so long as such information remains a trade secret under applicable law. Number 12, independent contractors. The parties are independent contractors, and nothing contained in this agreement shall be construed to constitute the parties as partners, joint ventures, co-owners, or otherwise as participants in a joint or common undertaking. Remedies. Each party's obligations set forth in this agreement are necessary and reasonable in order to protect disclosure and its business. Due to the unique nature of disclosure's confidential information, monetary damages may be inadequate to compensate disclosure for any breach by a recipient of its covenants and agreements set forth in this agreement. Accordingly, the parties each agree and acknowledge that any such violation or threatened violation may cause irreparable injury to disclosure and, in addition to any other remedies that may be available in law, in equity or otherwise, disclosure shall be entitled to obtain injunctive relief against a threatened breach of this agreement or the continuation of any such breach by recipients. Number 14, miscellaneous. A. Governing law. The validity, interpretation, construction, and performance of this agreement and all acts and transactions pursuant hereto and the rights and obligations of the parties hereto shall be governed, construed, and interpreted in accordance with the laws of the Federal Republic of Nigeria without giving effect to principles of conflicts of law. B. Entire agreement. This agreement sets forth the entire agreement and understanding of the parties relating to the subject matter herein and supersedes all prior or contemporaneous discussions, understandings, and agreements, whether oral or written, between them relating to the subject matter hereof. C. Amendments of waivers. No modification of or amendment to this agreement, nor any waiver of any rights under this agreement shall be effective unless in writing signed by the parties to this agreement. No delay or failure to require information No delay or failure to require performance of any provision of this agreement shall constitute a waiver of that provision as to that or any other instance. D. Successors and assigns. Except as otherwise provided in this agreement and the rights and obligations of the parties hereunder will be binding upon and inure to the benefit of their respective successors, assigns, heirs, executors, administrators, and legal representatives. The company may assign any of its rights and obligations under this agreement. No other party to this agreement may assign, whether voluntary or by operation of law, any of its rights and obligations under this agreement except with the prior written consent of the company. Notwithstanding the foregoing, confidential information of disclosure may not be assigned without the prior written consent of disclosure, unless the assignee shall be the successor entity to the assigner upon the dissolution of the assigner in its present form. E. Notices. Any notice, demand, or request required or permitted to be given under this agreement shall be in writing and shall be deemed sufficient when delivering personally or by courier or sent by email or 48 hours after dispatch, addressed to the party to be notified at such party's address as set forth on the signature page, as subsequently modified by written notice, or if no address is specified on the signature page, at the most recent address set forth in the company's books and records. F. Severability. If one or more provisions of this agreement are held to be unenforceable under applicable law, the parties agree to renegotiate such provision in good faith. In the event that the parties cannot reach a mutual, agreeable, and enforceable replacement for such provision, then I. Such provision shall be excluded from this agreement, and 2. The balance of the agreement shall be interpreted as if such provision were so excluded, and 3. The balance of the agreement shall be enforceable in accordance with the terms. G. Construction. This agreement is the result of negotiations between and has been reviewed by each of the parties hereto and their respective counsel. If any, accordingly, this agreement shall be deemed to be the product of all of the parties hereto, and no ambiguity shall be construed in favor of or against any one of the parties hereto. H. Counterparts. This agreement may be executed in any number of counterparts, each of which, when so executed and delivered, shall be deemed an original, and all of which together shall constitute one and the same agreement.